Then I have to share. And then let's do this.
Thanks for calling. As a provider of comprehensive products for each stage of your discovery, iPro is thrilled to sponsor this CCCBA Basic Trial Skills Education Series, and specifically this session on what do you want and how do you get it, framing issues and drafting pleadings. A lot goes into effectively managing discovery to ensure you build a strong story supported by your evidence. iPro's Trial Director for Trial Presentation allows you to streamline your pretrial, trial, mediation, and other litigation presentations with an intuitive solution that allows you to deliver exhibits, videos, and transcripts seamlessly to allow you to engage your judge and jury. It offers proactive and reactive approaches to demonstration, giving the user full control as to how, when, and where exhibits are to be presented. With a dynamic presentation screen, you can transfer, navigate, annotate, and many more customizations to deliver the most engaging and convincing form of presentation. When used with iPro's solution for e-discovery and information governance, you can gain insights into this evidence earlier in your processes, allowing you to respond confidently and accurately and win your case. I'll be a guest speaker on the final session of this series on creating trial presentations, where I'll offer best practices for you to use solutions to present your case and evidence by using visuals. Thanks for having me today.
Okay, thank you, Ethan. Okay, I'm going to now turn the program over to Andy Verriere, the let's see, you're not the chair anymore, the member of the litigation section board, who's been working and spearheading this program and is our moderator today. Andy?
Thanks, Ann. Like Ann said, my name is Andy Verriere. I'm actually no longer a formal member of the litigation section. I was a co-president last year, and now I'm the liaison to the litigation section from the board of directors. I'm a shareholder at Hartog, Baer, Zabrowski, and Verriere down in Orinda. And today we're here to talk about crafting pleadings. And with us, we have Mark Hilliard and Brittany Hendrix-Smith, who are going to walk us through the fundamental basics of putting together pleadings both in civil and family law. What we're going to do is start with the civil portion of it, and then we'll move on to family law. If you have questions, you are welcome to put them in the Q&A box or the chat box, and I'll be jumping in and interrupting them if it seems right to do so. Otherwise, I'll hold it to the end and we'll get through them at the end, but we'll do our best to make it through your questions. So Brittany Hendrix-Smith is a family law attorney as well as a certified mediator. She serves clients in Contra Costa and Solano counties. She graduated from UC Santa Barbara and received her JD from Chapman University School of Law. She previously worked for the Prison Litigation Project in the Ninth Circuit Court of Appeals Office of the Circuit Executive and worked with the Ninth Circuit's Alternative Dispute Resolution Committee. She has taught classes in multiple California jails and prisons, including developing the curriculum for the first ever college-level human rights course for inmates at CRC in Norco. She has since taught this course in several different penal institutions throughout California. In 2015, Brittany founded the law offices of Brittany Hendrix-Smith and began practicing exclusively in family law and mediation. We've also got Mark Hilliard, who is a partner at Brothers Smith in Walnut Creek. Mark has extensive experience trying cases in both state and federal court, including outside of California, and in resolving cases through arbitration and mediation. Although his legal career has primarily focused on high-stakes civil litigation concerning businesses, employment, contract, and tort disputes, he also has experience representing clients in estate litigation and a variety of industries. Mark was selected as a Super Lawyers Rising Star in civil litigation from 2013 to 2020, and was selected and recognized as a super lawyer in 2021. Along with other accolades, he has been awarded the highest peer rating of AV Preeminent from Martindale. So thank you to both of you, and I think we're going to start with Mark.
All right, good afternoon, everybody. I see we've got about 7 or 8 people, so I think that's really good because I think that this, to the extent that this can be interactive, it's probably going to help. So if you have questions, I strongly encourage you to ask them, raise your hand, put them in the chat box, whatever. Pleadings and even persuasive pleadings isn't exactly the most riveting thing in the law, and I freely acknowledge that. So we're going to do our best to keep everybody awake and interested. And I think that the more it can be engaging, probably the more it'll help. So with that, I'm just going to go ahead and kind of dive in. I kind of have this presentation organized into 4 or 5 different parts. The first is going to be kind of leading up to getting to the complaint. Then we're going to talk about complaints. Then we're going to talk about answers and counterclaims. Then we're going to talk about demurs and kind of striking the pleadings and that. And I'm going to assume, I know that obviously we've got a number of, I'm going to assume it anyway, that we have a variety of levels of experience on the, among the attendees. And so I'm going to try to make this kind of a, for everybody. So you'll hear some things that I'm sure that you already know, and you may hear some things that, you don't know or that you didn't realize or little tricks or things like that. So I should add that Andy, even though he didn't introduce himself, is a very experienced litigator in his own right. So he'll be a good moderator for this and should keep us all tuned in. So the very first thing I want to talk about when you're talking about crafting pleadings and doing a good job of it, and I'm going to use good job as basically interchangeable with persuasive, because that's what we are doing when we're in court, is we're being advocates. And at the end of the day, that's really what matters. The very first thing and the most important thing you're probably going to hear me say is that you've got to meet with your client. You have got to have a very good line of communication with your client to learn the facts, because obviously the facts have to fit the law. And so the facts, the good, the bad, and the ugly, you've really got to get that. One little trick that I've learned over the years is to bring with me, printouts of the various Casey provisions. Everybody knows what Casey is, I think, the jury instructions in civil court, in case you're not used to that or you haven't litigated or tried a case yet. But Casey is basically, think of it as like the ultimate law school outline. It's got every element, it's got everything you need. It's a great checklist for just about everything. And I like to, find out a little bit about what the client needs. This is going to be a contract case, or this is going to be a product liability case, or whatever it is. And bring with you the relevant cases so that you can actually pull those up with the client and kind of look at them and talk through those and say, yes, we can meet this element, we cannot meet this element, let's talk about how we can get there. That's really going to help you craft a good complaint out of the box, and one that's A, not going to be subject to demur or attack, and B, one that's going to hopefully be persuasive. One of the things you're going to want to do when you meet with your client is you're going to want to try to avoid pitfalls, avoid putting things in there that are going to be, facially problematic for you when the opposing party gets the complaint and they say, all right, well, we think we could shut the case down or what have you, and pleading around things. So if you have an issue with one inconvenient fact, get ahead of that fact and put it in there, but address it to the extent that you can. Now, if it's just a fatal fact, you've got to counsel your client, you've got an ethical obligation. But since we're here to be persuasive about pleadings, I'm going to leave the ethics for a different presentation. But you definitely want to be in a position where you've talked with your client, you know kind of what's going on. Talk to them about statute of limitation issues, other bars to relief. And then another good thing that I always try to tell, associates and other folks that I work with who are maybe a little less experienced is inform the client in writing. Tell them what you think. Be free. Use the attorney-client privilege to your advantage, knowing that it's never going to see the light of day. This is what I think, Mr. or Mrs. Jones, and I think that the problem is here, here, and here. This is how I propose to get around it. What documents do you have? Ultimately, your client's going to be asked for that in discovery anyway. So it's good to kind of get a good foundation on your case and to start that off right away. So that's the first thing. Then the next thing you're going to do after you visited with your clients, you're going to determine how to proceed. Are you going to go to ADR, mediation or arbitration? Is it binding or non-binding? Or are you going to go right to litigation? So oftentimes this is going to be dictated if it's a contract case that calls for arbitration. A lot of construction litigation cases will call for mediation, then arbitration, then litigation. And actually, even before that, you may have an obligation to try to informally resolve it by picking up the telephone. So be aware of where you're going and think about that, and having having given that some thought, then visit with your client and kind of get on the same page with them. The other reason that that's important, at least in my view, has to do with the cost. Certainly clients, I mean, I would say all of us, but certainly most of us have had a client that called and said, hey, I didn't expect that my bill was going to be this or that. And, you have to explain. If you have explained that ahead of time, you're going to be in a much better position. It's going to help you with your client relationship. And that's going to be a better team that goes out to play in this thing we call litigation. So definitely
Mark, on that part where you're doing this first meeting with the client and you're gathering the facts, do you have any any tips for how to keep the emotionally invested client on track with respect to what you're talking about?
Yes.
I've had the experience where they're so wrapped up in this history of the case, and they're coming to you and they almost just want to have this cathartic moment. How do you keep them on track for the issues that are going into the case and keep them focused on what's before them?
Yeah, so this is a little bit where you're wearing your lawyer hat and your psychotherapist hat a little bit. And, we've all kind of been there. I think the thing to do is you've got to really kind of, for lack of a better term, there's got to be a little bit of kid gloves and some empathy. I think if you told the client, for example, and the client just wants a pound of flesh and he doesn't, or she doesn't care, and they just, they don't care about the law and they really don't care about the facts, they just feel wronged. Well, Mrs. Jones or Mr. Smith, I understand how you feel and I fully understand that. We're going to get to that. But right now, help me focus on the facts that are going to support our claim so we can go carry out what you want to do. And immediately you can almost in their mind, they just sort of snap back to, yes, okay, now I'm back training, and they get out of the emotional loop and they kind of start to focus. The other reason that, the other thing I think, Andy, that's really good, it's a great question, is having Casey, because now you can talk objectively about facts as they relate to law. And what you didn't hear me say is emotion. You don't have any of that. You can just set all of that aside. It's a great question. It's something that everybody on this call either has or will encounter in their career in representing clients. No question. Yep. So then the next thing, I'm going to assume that we're going to go to a complaint here. Mediation and arbitration are a little bit, they're a lot easier actually. You've got JAMS or ADR services or the American Arbitration Association, the AAA, and they all have their own forms. And so it's very heavily form driven. So you file your demand for arbitration and you just kind of fill that out. Now, one thing you can do, we're going to set litigation aside for a moment, just talk about ADR. Whether it's arbitration or mediation, you can fill out that form, but with it, you can fill out and complete an actual custom complaint, just like you would do for litigation, and attach that. And then what you've done is you're not confining yourself to that box that's 2 inches tall with 14 size font. You've got a little bit more you can say. You've got a little bit more of a palette with which you can be persuasive, and you can tell the judge and the arbitrator and the mediator kind of what is on your mind, what's on your client's mind. So that's that. Arbitration and mediation are fairly self-explanatory, and we can get into the pleadings with those, but suffice it to say that an answer usually comes back. It will depend on the firm and maybe, whether you're in arbitration or mediation, and then depending on what body, but usually the other side doesn't have a deadline to file an answer. There may be some rules, but those rules are largely suggestions, I find, in arbitration and mediation, because it's much less about litigation and, this is this and not that. And, this is right, this is not right. There's rulings. And it's much more about, a neutral basically getting to just consider the field of evidence and make a judgment based on that. They determine what is relevant and admissible. There's no motions in limine. So you don't have this really strict procedure. So usually an answer during a mediation arbitration will come back as a letter form, in the form of a letter. And they'll say, we hereby deny everything. And, we believe that our claims are merited, and this is what we're going to cross complain. And that's basically the pleadings in that. So there's not a lot to talk about with that. So if you have any questions, you can always email me or whatever. So I'm going to go into the complaint unless there's another question or anybody has anything on that, which I doubt it, but if you do. So then moving toward the complaint. So a complaint is obviously the vehicle through which you commence litigation. And the goal is really to provide notice to the opposing party of the material facts that support your claims or your client's claims that are persuasively written and that tell a story. And those are the three things that you try to basically accomplish in a complaint. And it's a little more nuanced than that. But you got material facts, persuasively written, that tell a story. And I guess a fourth would be keep the jury in mind. If you're going to have a jury trial, if your client wants a jury trial, think to yourself, this complaint could see the light of day in court at some point. It's an admissible pleading, and it could come out. And on defense, there's a lot of things that defendants like to do with pleadings. For example, if a plaintiff sues 10 different defendants and there's one left at trial, that one is going to want to put that complaint up to show that there were 9 other defendants, because then the jury is going to say, well, did they settle? Is there other fault to go around? And you don't even have to introduce evidence on it. It's just kind of like a free space. So be thinking about what is going to happen with this complaint, and would a jury see it? If a jury sees it, what is that going to mean? So you want to be persuasive. You've got verified complaints, which are complaints that are basically attested to under oath. We'll get to that in a second. You've got unverified complaints, which I think represent the vast majority of complaints filed in civil litigation, certainly in our county. And so regardless of whether it's verified or unverified, one thing to remember is that you have binding admissions in those complaints. So even if your client doesn't verify it and you say that the light was green, and you get to trial and you try to take the position that the light was red, it basically almost becomes an RFA to use against your client. It's a binding admission. And it's really not even almost. It has the same evidentiary effect. So be very careful what you put into the complaint. But at the same time, you need to give them enough facts to meet the causes of action and properly plead them. Otherwise, you're going to be subject to demur, and they can attack your complaint. So on the form, you've got a couple of ways you can do it. You can do a custom complaint, which everybody sees and very familiar with those. It's on pleading paper, and you've got the caption at the top, and you've got your, he comes now so-and-so plaintiff and blah, blah, blah. And your statement of venue, your statement of jurisdiction, your statement of the parties, your statement of facts, and then your counts, your causes of action, your prayer for relief, and your demand for a jury. That's basically a custom complaint in a nutshell. And then there's a judicial counsel form as well that you can use. I would encourage people who have a client that's working on a budget to try to use the judicial counsel forms, because I find that, it takes a lot of the work out. It certainly isn't nearly as persuasive a pleading, but it can be, because there are attachments that you're allowed to use for those that you can plead your causes of action, just as you would if, by typing out some great big, nice captioned, custom complaint. So something to consider. But for fact pleading, which is what the standard is in California, you've got to have the facts that meet that support the causes of action that you're pleading. You're going to need you're going to need attachments to that judicial form. And so always look at the rules of court also for what you need in order to, and how a complaint has to be set up. The judicial counsel forms have already done that for you, but if you're going to do a custom complaint, you're going to want to look at rules of court 2.100 to 2.119 and 3.20. Those will set you up with, how many inches and how far this has to be and how, all of that. A lot of people, I realize, have programs that spit these things out, which is really nice. But, it's always good to look at those. And actually, it's always good to look at those if opposing counsel comes back with some really odd looking complaint that just is completely misformatted, because you may be able to bounce it and cause them a little extra, time and expense, which isn't the goal certainly, but let's be honest, it never hurts. And I should mention, I come from a litigation background, so that's probably why I take that approach. I've done civil litigation for about 15 years. I did a lot of product liability. I've done toxic tort. Now for the last 4 or 5 years, I've largely done business litigation. So plenty of pleadings, both on the plaintiff side and on the defense side. So verification, we talked a little bit about, you can have a verified or a non-verified pleading. A verification, basically what it is, it says that the contents of the complaint are true and correct. It will expose your client, to direct, cross-examination. I'll say, isn't this your signature, Mr. and Mrs. Smith? Yes. So you said that the light was green. And it really does set your client up. And so I tend to advise against verified pleadings unless you're in a position where you want the other side to respond in a verified manner too, because a verified complaint will require a verified answer. So if you want to basically get a little bit of discovery out the door, out the box, what you can do is file a verified complaint, and the other side will have to either admit or deny each one of those verified statements. And if you're going to do a verified complaint, make sure you break down the facts. Do one fact per paragraph, and on and on and on. Don't have 2 or 3 facts in a long paragraph, because then they can kind of, it gives the other side a little bit more wiggle room. You know, the light was green. You know, Mr. Smith, his light was red. He blew through the light. He struck the vehicle. This is what happened. Just set it out really like that, because then they're going to have to go through and admit, deny, admit, you know, or say that they don't have a basis on which to admit or deny. So
Mark, you mentioned earlier this concept of judicial admissions, and that when you put allegations in your pleadings that they constitute judicial admissions that are binding at the end. Do you have any thoughts on amending pleadings to fix that, and how that might differ when you've got a verified complaint that you're trying to amend, when it comes out in the course of discovery that perhaps the facts or the evidence supports something different than what your client originally verified?
yeah, so this is why, one of the reasons Andy just pointed out, why I don't really love verified complaints if you can avoid it. The reason being is that it's always going to be there. A lot of times, and there's, at least in the federal law, and I'm not sure if the state law follows this, but the Ninth Circuit certainly does. So I would imagine that it would, that our state would. If you have a complaint, then you amend the complaint. If it's unverified, the prior complaint is of no effect. Okay, so that's basically the way that it comes out. Now you can use it while it's in effect, and you may even be able to use it for cross-examination and say, well, didn't you say this? Now you're saying that. Whether that's admissible is another question for evidence and for a judge, and really that's factually dependent. But yeah, absolutely. If you say that, now I will say this, if you say that the light is green, let me back up a step. The judicial admissions is going to apply to facts, not argument, not law, not a position that you're taking, but a fact. If you say the light was green, if it is that obvious, and then on an amended complaint, you come back and you say that light was red, you're going to get run out of court, because you cannot just ignore what you've pled before. What you could do is that you could say, well, the light was green, and then amend and say, well, the light was green when I was in this particular position relative to the light, which caused me to believe it was green. So you can't say it was green. Oh, now it's red. It doesn't work that way, just because it's an inconvenient fact, and you will get either a motion for judgment on the pleadings or a demur, and you will not have leave to amend almost certainly for that reason. So does that answer it, Andy? I think that's about what you were asking.
Yeah. I mean, the idea is that you've got to be able to explain the differences amongst your amended pleadings, and in particular, if you verified it, you know, that's a sworn statement that's going to carry through across the pleadings and throughout discovery and into trial.
Absolutely. And even after, if there's subsequent litigation or appeals. I think I would tell you guys this as a rule of thumb: it should be a non-verified complaint unless you are absolutely holding a full royal flush of a case, and you know that there's nothing really out there that's going to, you know, come back to get you, and you want discovery early. In other words, you really got to have a good reason to do a verified complaint. I've done them. I've had reasons to do them when I wanted to know what the other side was going to say in response to a certain thing, and I wanted to play rope-a-dope. Then I've got a good client. You can do that. But ultimately, you probably are going to want to start from the position of making it an unverified complaint, and then maybe, you know, consider making it verified if you feel like you've really got, you know, the goods in the case.
So Mark, does that verification concern ever inform the claims or causes of action that you assert on behalf of your clients, to avoid certain ones that may require that the complaint be verified?
There are certain causes of action that require verification. You can work around that, certainly. You know, that's a discussion when you're talking to your client. You know, that's why the most important thing I'm going to say is you've got to talk to your client. You've got to have a good foundation on which to build your case. You know, we wouldn't build our house on sand. So you want to have a good foundation here. So yeah, you know, if your client has concerns about certain causes of action, or has some, you know, just really doesn't want to verify it, feels very strongly against that, or has some skeleton in the closet, for lack of a better term, or what have you, then that certainly can inform whether you verify. And actually, who verifies is another thing I was going to raise as well. You know, if you've got an individual client, that client should verify it. The attorney can verify it, although this is highly not recommended, because then, you know, you're kind of putting yourself in the spotlight a little bit. You have to have good cause. For example, your client is incompetent, but then you're going to assert a competency defense anyway, but you could verify that. Your client is out of the country, you could verify that. But I'm going to tell you as a rule of thumb, never, as an attorney, to the extent you can avoid it, don't verify complaints for your clients. If it's corporate, or you know, whether it's a partnership, it could be a partner. If it's a corporation, it could be a director, or it could, and whenever it's an entity, it can always be on information and belief. That's really the only time it can be that. If you have an individual, they just need to say this is true and correct. It can't be on information and belief and all of that. If it's an entity, it can definitely be and should be on information and belief. Don't confuse those rules. I have accidentally, just a little story, I kind of embarrassed myself one time, sent a nice meet and confer letter when some corporation early in my career verified on information and belief, and I went, BS, that you cannot verify on information and belief. It's a verification, darn it. And I ate a lot of crow and ended up reading some Rudder Guide later that day and didn't feel as good. I had to pick up the phone and call the other guy and say mea culpa. So not a good place if you can avoid it.
And Mark, I've seen the opposite, where a individual verified it on information and belief, and the judge struck their verification because it was improper under the code. So you're absolutely right. That cuts both ways.
Absolutely. Absolutely. So then the next thing to kind of consider with your client is, are we in limited or unlimited jurisdiction? Vast majority of cases are going to be in unlimited, which means it's greater than $25,000. The minority of cases are going to be limited, which means it's $25,000 or under. And you're going to have to consider this based on what is the maximum recovery in the case. You know, what is this case worth dripping wet? What can I get out of it with everything? That's how you kind of calculate that number. I wasn't planning on talking about this, but just because it kind of came up in this, or comes up in this context, if you get somebody that files a motion, a case in unlimited jurisdiction, and you're looking at it, and the prayer for relief says that they want $15,000, or you know, some number that you know this ought to be in limited, you can file what's called a Walker motion, and you could get it reclassified down to limited. The benefit to being in limited when you're a defendant is it's limited discovery. You get one deposition, you get, you know, I think it's 10 of each, special interrogatories, RFAs, RPDs, something like that. I don't have all of the stats and figures, but the point is that it's a much smaller version of the case, really. So as a defendant, it's good to be there because obviously there's only so much information they can ask for. You know, as a plaintiff, it's possible that you want to be there too, because then you're going to save your client some money. So a couple of things to think about on that. Jurisdictional issues, you're going to want to think about forum and venue. You're going to want to think about personal jurisdiction and subject matter jurisdiction, and federal and state. These are all considerations that you're going to have to basically raise and discuss with your client prior to filing. So, you know, do you have jurisdiction to go to federal court? Do you have, you know, complete diversity? Is it a subject matter issue? Is there a personal jurisdiction question? Is, you know, what is it? Is it a federal question? So you've got a number of things that will get you to federal. Of course, we could do a whole thing on that. You know, personal jurisdiction and subject matter jurisdiction. Are you filing the case where the action arose for subject matter jurisdiction? Is your person in the state? Are there sufficient minimum contacts within the state under Ballman, AG, which is a huge case on personal jurisdiction from the U.S. Supreme Court? And there are a number of those matters. So you get somebody that lives in Idaho that, you know, used to live in California, and they claim that, you know, your client sold them some product in Washington, but they're going to sue you here because this is where you are. And they know they can get a big jury verdict in San Francisco because it's so plaintiff friendly. And so they go and they file there. And maybe you've got a PJ motion you could bring. Little fun fact, I love personal jurisdiction. I don't know why. I think it's very interesting. I love the constitutional issues, and it's kind of like the constitutional issue of pleadings. I've done and won a bunch of PJ motions when I used to represent Ford, and it's a lot of fun. So if anybody ever has a PJ question, wants to talk about it, give me a call and we can have a drink and talk on the phone about it because I love it. Okay. So I'll put my inner nerd back away. Naming the parties. Naming the parties. So you've got to think about who you're going to sue, and you should talk again with your client about what the import of that is. Are you going to sue somebody that you do a lot of business with? How's that going to affect your business relationship? You know, are you a subcontractor and all of your work comes through a general contractor and you're about to go, you know, sue them for a couple $1 million? How's that going to work? Is there going to be a fallout? So you've got to think about this. You've got to think about naming people in individual capacities and talk with your client about the comfort level for that. And then when you're going to name them, the way that you name an entity is, or an individual, is you got to name them for what they are. So, you know, Andy Verriere, comma, an individual, you know, semicolon, you know, Procter and Gamble, a Delaware corporation, you know, whatever it is. So you're always going to want to have the representative capacity, and you're going to do that for a number of reasons, because it will help to remove certain jurisdictional defenses from a responsive pleading. If you go ahead and put that in there, you know, it's gonna, there's not a question, in other words, whether the state will have jurisdiction or not. If it's a corporation, it will do business there, or maybe it's got, you know, documents on the Secretary of State. So always name them in their representative capacity. Another thing, if it's a representative, if it's a trust and you're suing the trustee for, you know, mismanagement or what have you, conversion, whatever it is, you know, and, you know, Bob Jones, comma, trustee of the blah, blah, blah trust. That will certainly help things, and it actually will straight line your pleadings. Let's see here, does and rows. Does are for complaints, rows are for cross complaints. I think everybody pretty well knows that. Always include some does, always include some rows. I would say that usually the more moving parts in the case, the more complex the case, probably the more does or rows you want to have. I never understood these people that have like a common counts and they're like does 1 through 100. I'm like, you couldn't name 95 other parties, like, you know, so like, I just don't get it. But anyway, the other thing you're going to want to think about is where you put the does and the rows, because you're going to want to break them up. So as you get into your counts and you're going to plead the counts, think about what bucket of defendants or bucket of plaintiffs, if it's a cross complaint, you're going to want to assert that. So for example, let's say it's a construction case. You've got 2 lenders, you know, you've got a general and an owner. So you're going to want to break those rows or those does in this case up into, you know, 3 parts. And basically you're going to want to allege the causes of action against the does that will be relevant to that. So if it's a cause of action for, you know, mechanics lien, you don't want to allege that against a certain group of does, because those aren't going to be owner does. Allege it against the owner does, make those 8 and 9. So against, you know, this owner and does 8 and 9. So just divide them up based on, and it's almost like a mathematical process. There's been a lot written on this, but basically you don't want everything to be alleged against does 1 through, you know, 25 or whatever. All right, so let's move on a little bit here. Then we're getting into causes of action. We're going to list those individually. I like to list them in the order of importance, or in the order of chronology, so that you're telling a story. When you're giving your facts, so the way that you break this down is you're going to have your parties, your jurisdiction. You know, here are the parties. So and so is a whatever. So and so is a whatever. Your jurisdiction. The court has jurisdiction here because the action, you know, the facts giving rise to this action occurred within the county of Contra Costa. Then you're going to have your facts, and the facts are where you can really do the most persuasive damage, and you can get out in front of bad facts. And so list all of your facts. If it's verified, try to break them down. Even if it's unverified, try to break them down as much as possible. And then what you're going to want to do is you're going to want to incorporate those by reference into each jurisdiction, each cause of action. I like to go almost chronologically, you know, where the story leaves off on the section of facts, start your first cause of action there. You know, therefore, the Smiths were negligent. I'm going to include that. Going back, negligence. When you're talking about the parties, if there is an insurance company, or if you think that the people may have insurance, always include some variety of negligence, negligent misrepresentation, negligence, you know, whatever. You can plead in the alternative. We're going to cover that in a second, but always do that, because the duty to defend is broader than the duty to indemnify, which means that if any cause of action in that complaint would be subject to coverage by the insurance company, they got to pick up the whole thing. I mean, it always gets, you always fight about it, but ultimately they know what they have to do, and that's what they have to do. So always plead negligence if you can. So I like to list the causes of action kind of chronologically. Refer back in the first sentence in every cause of action is, plaintiff or plaintiffs hereby incorporate by reference all previous paragraphs of this complaint. And that way nobody can on demur say, well, you didn't raise this fact. Well, it's incorporated by reference right there. The other thing is when you're preparing the causes of action, refer back to that Casey, the Casey provisions that you talked with your client about, because that's the checklist. So if it's, negligence, well, there was a duty, then they breached the duty, then there was proximate cause, and there's actual cause, and then there's damages. All right. So, plead the facts right along with that language and tell that story. Bob Smith had a duty to Sandra Jones. Bob breached the duty when he did this. Bob proximately caused it. He actually caused it. And Sandra suffered damages like these. Tell that story, because it's going to make a very personal, persuasive type of story within the cause of action. You're going to especially need to plead. In other words, there's what they call a heightened pleading standard for certain causes of action. You've got to put in all the facts that alone would support these causes of action. This is not an exclusive list, but any fraud-based cause of action, fraud, misrepresentation, things like that, conspiracy, you got to say the who, what, where, when, and how of all of these, agency, and punitive damages, and declaratory relief. For dec relief, you have to show that there's an actual controversy between your client and the other guy, the other person, the other party. And so, just be aware that there can be heightened pleading standards. And if you just go through and you try to just give them the basic minimum, and you don't say the who, what, where, when, and how, you may be subject to demur. You may have to amend. It's just going to cost your client more money. So if you can do that out of the gate, that's going to be certainly a positive thing for your client. Pleading in the alternative and inconsistently is perfectly okay. This, as a young lawyer, I had to kind of get my head around, because I'm like, wait a minute, you're going to take this position in a legal document, but you're going to say that it was intentional misrepresentation, but it was also negligent misrepresentation. How can you do that? So here's the deal. This is really where the fine line is. You cannot plead inconsistent facts. That will definitely land you in demur purgatory, and that's not a good place to be. So don't say the light was green, but if it was red, or the light was green and and it was also red in different causes of action, that will be a demur for uncertainty, and you'll never see the court. You can absolutely have a set of facts and then say it was negligent, it was intentional, it was whatever, because you don't know exactly what the evidence is going to be yet. You haven't done any discovery, and you don't know. You haven't taken a single deposition or fired a shot. So always plead in the alternative if you can, because the more causes of action you assert, usually the more robust the case is. It's easier to omit a cause of action if it doesn't meet the standard later than it is to try to go back and add something that you knew about or should have already pled, because you're largely going to have waived that. The other thing is, for each cause of action, identify the party suing and the party being sued. Usually for the party suing, that's easy. Alleged by all plaintiffs against, and then it's either, all defendants or, all these defendants. You can define, product defendants or warnings defendants, doctor defendants or insurance defendants, things like that, subcontractor defendants and general contractor defendants, and then does whoever. So always you're going to have, first cause of action, negligence, alleged against this, by this against this. Okay. Evidence with complaints that support your causes of action. There's a case out there. I can get the citation. I didn't have it for today, but I can absolutely get it. It says that basically, if there are documents that are relevant to your causes of action, that you have to disclose those. If it's a trust contest petition, you got to have the trust if you have it. If it's a breach of contract case and you're going to take the position it was a written contract, and by the way, if you're going to allege breach of contract, you got to state whether it was written or oral. or both, or either, or neither. I don't know how it would be neither, but there you go. You got to say it. So if it's a written contract, you've got to attach that contract. That can be problematic, and a lot of people don't, but that would be subject, that complaint that alleges breach of a written contract and doesn't attach it would be subject to demur on that basis. So if you have to attach the contract and it's negative for you, or if it's got some bad information in it, or it's not helpful, then what you have to do is you've got to plead around it. You've got to find a way and talk with your client. How do we get around paragraph 3.1? It says you had to do this and you didn't do it. Well, I did this other thing, or my performance was excused because this. Then get in your complaint and say although the contract 3.1 says that Mrs. Smith had to do this, her performance was excused because of this. And I'm telling you, that's going to make a really good pleading, and it's actually, you're going to be doing your client a lot of good, because that's not going to be something that is going to have to come out in discovery and all the rest of that. You will have already explained it. So attach documents, and then to the extent you need to, incorporate them by reference. But be advised, if you attach a document, that's one thing. If you incorporate it by reference as though it is in the complaint, that has legal significance and it can be used against you. So you got to look at the document, and never, never, ever, ever attach a document that you haven't read. Always know what you're doing. Read every piece of ink that printer spits out before that thing goes off to court, and do it twice if you can.
That's a really important point, Mark, because I've seen on more than one occasion where someone's attached a contract to a complaint, spoken about one portion of it and ignored the remainder, and the remainder just eviscerated their entire case. So everyone really should take that to heart. Read every word of every document you attached, because that's incorporated for purposes of demur, and your case can get bounced out of the gate if you haven't. And it may militate against bringing the case altogether.
Yeah, absolutely. And the other thing is, and I mean, I hate to be the state the obvious, but I think it can help to state the obvious sometimes. Know what the legal significance of the words you're using are. Just because a lot of folks say, it's incorporated by reference, know what the legal significance of that is, because there is legal significance. And if it does, get to what Andy just said, if well, paragraph 1 says you didn't do, you have to do this, you didn't do it. Yeah, but paragraphs 5 through 7 say I don't have to do it, if some other condition. So they just ignore that. So definitely read and by the way, there's another good, just while I'm on the topic, definitely read the cases you cite. Don't just cite them wholesale for one proposition without reading the whole case. You always got to read the whole case, because these judges, especially the older cases, you just flip another page and but on the other hand, and you're going, well, I didn't read that part. So just good way not to get embarrassed, which we're all trying to help each other do. You're going to need a prayer for relief. The prayer for relief is important. Here again, there's legal significance. It's not just some arbitrary thing that we just do, snag a prayer for relief because that's what we've done in this state for the last 150 years. I would include it as to every cause of action. So if it's a large complaint, first cause of action, negligence, we want this and this and this. Second cause of action, we want attorney's fees because maybe they're provided for, or costs or whatever. And so break it down by cause of action if you can, and be sure to state what the sum of the relief you're seeking is. Dollar figures if you can, because here's the deal. If you go and you get a default judgment, the other side can set it aside. Let's say you get a default judgment for a couple $100,000. You're going, yeah, great, we won. Haven't got a court judgment yet. We got a default, and that's good. And now I'm going to go try to levy on some things and take a debtor's exam and see what's what. And so you're sitting there, and then the other side files a motion to set it aside. And they say, well, in the prayer for relief, they didn't specify the damages. They just said money damages. Well, what that means is that your $400,000 judgment that you got is going to be set aside. And the most that you're going to be able to collect is $25,000 and not a penny more, because that is the maximum that's the minimum jurisdiction of the court. So believe me, I've seen this happen. It happens more than people realize. I didn't learn this until this year. I'll follow my story on that one, but you've got to plead the exact specific money to the extent you can. The way I would do it is, let's say your client is owed contractually $71,000, at least $71,000 plus interest and cost and whatever the court finds appropriate. That is that's sufficient notice, but definitely state some of the damages and request, fees, request everything you can, request injunctive relief if you want, so on and so forth. The other thing, I want to go back to verified complaints and injunctive relief, just reminded me briefly. You can get a TRO, a temporary restraining order, which is injunctive relief, on the basis you can use a verified complaint as the declaration in support of that. That would be a good reason to use a verified complaint. Outside of that, there's not really a great reason to use it. So I just wanted to mention that. You got to sign it. It's a required certification that there is merit to what you're doing or what your client is bringing. So you've got to sign it. If you don't sign it somehow, you have basically, I think it's, a reasonable period of time to promptly correct it. I'm talking like a matter of days. So the clerk's not even really supposed to accept that. The clerk can never deny a pleading on the merits, but they can absolutely have the authority to deny a pleading on the forms. So if the form is wrong, whatever, something isn't proper, they can reject that pleading and it will not get filed. So definitely, try to check everything out and make sure that you sign it. It's an easy thing, but sometimes it's worth spending a second on the obvious. If you've got mixed actions, which I'll call mixed actions, let's say you've got you want to assert a lien against a client, but you've got a contract that says you've got to arbitrate. So what do? You can file the case, and then, for example, under CCP 1281.5, you can put language in the complaint that says that within 30 days of service, you intend to stay the complaint to move for arbitration. That allows you to proceed on two tracks. So you have the complaint that's still live, but it's stayed frozen on the lien. Then you can go file for arbitration, and then you're all good. So you can there are ways to do mixed actions. I'm just picking one that recently came across my desk, but there's a number of these that kind of happen. The other documents to be aware of serving, you need a civil case cover sheet. You need a summons. That's the most important thing it's kind of like having a car with no key if you've got a complaint with no summons. And then you also always want to be looking at the local rules to see if there's anything that's helpful there or required in addition. And I cannot overstress this to the younger folks of whom I used to be one. Always read the local rules. They're rife with information that you will not have known or realized if you don't read them. Don't assume them. And I promise you, if you know the local rules and you've actually taken a look at them, or just usually what I do is if it's in a county I'm not familiar with, I just print a copy and put it in the file or save it as a PDF to my desktop. And then I can access them really easily. It's also a great way to get over on the other side. So if the other side, LA County, I'm from LA, I practiced in LA for a long time. LA County local rules require you to meet and confer with opposing parties prior to noticing a deposition. So you got to do that. And if you don't do that, you could wind up getting your deposition struck or basically getting the objection sustained.
Hey, Mark, just because we got a limited amount of time and I know that we could talk about pleadings for a week. Why don't we try to get through answers really quickly, and then we can turn it over to Brittany to hit on some of the family law issues.
Absolutely. So, in answer, you got to refute the material facts in the complaint. The format is a little different in federal and state. In federal court, you've got to go paragraph by paragraph by paragraph and respond to each one by number. As to paragraph 6, the defendants deny it or whatever it is. So you got to treat it like a verified complaint. Be aware of that. You've got to include affirmative defenses that you have. I would include as many as you can think of that are reasonable and pertain. I would not include punitive damages affirmative defenses where that's not an issue in the case and so on. Otherwise, they're going to be waived. And then remember, there could be a form interrogatory 15.1 that comes your way on an answer. The plaintiff says, hey, for every answer you've alleged that I have unclean hands, affirmative defense number 47, what are your facts? And if you don't have facts, then you're not going to have much to say. So always be thinking ahead. The goal is here, talk to your client, get the facts, know what you're doing, have it all prepared, build a good foundation, and realize that what you do today isn't just some pro forma thing and filing a complaint. It's going to have, manifesting long-term consequences in the future. So let's stop there, I think.
All right, great. Thanks, Mark. I appreciate it. We may have some questions at the end, but for now, we're going to turn it over to Brittany, and she's going to give us a rundown on the pleadings in family law actions.
All right. Okay, so I'm going to get this PowerPoint going. Let's actually start it at the beginning. All right, everyone see that okay? Yep, okay.
Great.
Great. Okay, so after hearing that, I've realized family law in the pleading sense sure allows a lot of shortcuts and shortened ways to plead things. I'm going to go over just kind of the basics real quick. I put in a lot of information that you can reference if you're ever doing this, but it's I'll try and get to the meat of it. So there's actually a conversation about what we should and shouldn't be doing. So family law is extremely form-based. Before you start to ask yourself, is there a form for that? Chances are there are. It's when it comes to things like personal jurisdiction, figuring out who's a party, figuring out the correct venue, figuring out the basis for your relief, all of this in forms. It is there for you. The great thing about family law is that ultimately we're only dealing with a few umbrella issues. There's a ton under that umbrella, but ultimately we're looking at, can these people get divorced? Questions like, were they married? Do they want to get divorced? These are things that do not usually require much proof, and so are pretty easy to take out in a form. After you check to see if there is a form for that, ask yourself, is there a local form for that? Just like Mark was saying, it is a huge amount of benefit to everyone if you can include local forms. Seriously, one of the biggest things I wrote, seriously, getting your filing kicked back because you missed a form is the worst. You are dealing with exceedingly anxious people who need things done now, who are thinking their whole life is collapsing in on them. They need something filed. When things get kicked back, especially after, you know, the past 2 years, it may take forever for you to get that back after it's kicked back. So checking for local forms in advance is going to be a huge help.
And Brittany, it looks like, you know, I'm no expert on family law cases, but it looks like one of the big differences here is that in civil cases, you've got these optional judicial counsel forms, but in family, this is mandatory and you don't have a choice but to leverage the judicial counsel forms.
Yes, and I kind of go over that a bit, but also it just is, yes, 100% mandatory, even if sometimes I will end up drafting things to look a lot like a civil motion or a civil complaint, and you just smack the required judicial form right on top of it like it's a cover sheet, because they won't even take it. No one will look at it unless that is there. So yes, it is extremely important. And if they are missing forms, they will send it right back to you. 3 very common types of family law pleadings: dissolution cases, which also includes legal separation and nullity. Parentage cases for custody if the parents were not married, and domestic violence cases, which is oftentimes a subset of the other 2. So all the cases have required forms for your initial pleadings. Oops, there we go. Of course, those aren't the only categories. There's also government child support actions, interstate actions, summary dissolution actions. Those are all a little more rare, and you don't see them as often. But if you go to the forms, you will be able to negotiate them, because everything you need to plead on a jurisdictional level is all established right in that form. And if you go through the boxes and make sure you check each of the boxes, you will get to each of the facts you need to get to. So different types of pleadings all have similar form requirements, but are often on different forms. I threw this out here just as a kind of a initial glance, so you could see that for a dissolution, you need an FL 100, but for a parentage case, you need an FL 200. Each type of these actions have very similarly organized forms, but they are specified to the exact type of jurisdiction requirements that are presented. So like I said, the initial pleading forms guide you through the related required jurisdictional questions. What court should it be in? What venue? What jurisdiction? Who are the parties? That's, it sounds a little easier than goes 1 through 100, certainly. Usually you can generally figure out who you were married to. You know, well, I shouldn't say you know the parent of your child, but you may have an idea if you are bringing it before the court. The party's relationship, who is this? Is this someone you lived with? Is it someone you're married to? Is it someone that you thought you were married to that you actually are not married to? These are all issues that can be brought up. Statistical facts, when were you married? How long have you been married? When did you separate? And information about minor children. So minor children is going to be an issue that requires additional pleadings. You'll see in the previous slide, the FL 105 will often be used to establish jurisdictional facts. The US kind of got it together to say, hey, we may want some sort of unified system so that when parents abscond with children to other states, someone may be able to get them back at some point, which in my experience is still quite difficult, but at least they're trying to put some things together and gather jurisdictional facts about the children. So there is a separate form for that. And then the legal grounds for the request, usually for a dissolution action that is irreconcilable differences. The other option is legal incapacity, which is, I've never seen it in actually all my years. I've seen lots of people try and put that on there. Yes, my husband's so crazy that I want to get rid of him due to legal incapacity. Now it's, you guys know this, but I've never seen it successfully pled. Usually if that's the case, it's going through the probate conservatorship route anyway, so. The type of relief you can request is all outlined in the form and depends on what kind of filing you have. For example, in a parentage case, you can get child support, but obviously can't get spousal support. You weren't a spouse. Property orders, you can get certain kind of property orders, stay away orders, move out orders. So you have injunctive relief, you have financial relief. One of the new things in dissolution actions now is that pets have been thrown into the mix as far as areas where you can debate custody. So now we have some dog and cat custody fights, which are always very bizarre to do, especially animals that don't travel well. You've seen people try and work out custody agreements for their lizard, and you're like, wow, okay, this is quite a way to spend your weekend. But so that is an option in a dissolution action now that is relatively new. You could also get property control of animals in domestic violence cases, but not in parentage cases. So if you want your cat back, make sure you get married. I think is the rule there. I threw in a couple items to remember. Filing fee when you start. No fees for domestic violence actions, just some information about service, and making sure that you are always accompanying anything you serve to the other party with a blank responsive form. I included in the materials just a quick little chart to say, if I serve someone with this form, what form do I need to serve blank along with it? Kind of just helps make sure you're getting all the forms in there. Responding to a petition. You can get a default if it's not responded to within 30 days. Defaults only do so much because the court probably will not just grant you the house and 100% custody of the kids because your ex wasn't organized enough to file something within 30 days. But people will try. It doesn't usually work out, and quite frankly, is I tell people if there's actual stuff you want to accomplish here, taking the default may not really assist you that much. So your pleadings are filed, now what? As in all the other cases, you're going to settle everything either by stipulation or trial. But with family law, they're going to need some orders in between. You've got people taking kids, you got people, emptying bank accounts, people quitting their jobs, people doing all sorts of bonkers shit, quite frankly, because, on the recording, but truly you do. It is just, you see a lot of crazy stuff in family law, which, is the fun counter to the fact that it is extremely high stress at all times. I sympathized with Mark's comments about client control and trying to reason with your clients about what is realistic. People come in with a lot of weird ideas about what they are entitled to. When they say, what am I entitled to as a parent? And you have to say, well, nothing really, technically. And what are my constitutional rights as a parent? Well, actually, they don't talk about being a parent in the Constitution, so none. People will try and sell their soul to get their kid another day. It is an intense area of litigation and
So
control.
Brittany, we talked about that a little bit on the civil side, and that's really the emotional side. And I guess Mark described it as wearing your therapist hat as well as your counselor hat. How do you deal with that on the intake in terms of keeping clients focused on what's really at issue in the dissolution proceeding or whichever proceeding you're involved in?
I mean, a lot of the times, and maybe this is an unpopular way to state it, but I think is more true. A lot of the times you just can't. You are in, I try and tell clients, you don't want to use me as a therapist. I charge more than a therapist and I'm less qualified than a therapist. Save your money, get better assistance with therapy. And I always try to encourage my clients to be in therapy. However, it is extremely hard to stop people from having an exceedingly emotional response. People are crying in your offices most days. People feel like their entire life is ending. It's usually the worst moments of someone's life in these proceedings, which is sometimes a little strange, but certainly a lot of times, especially with the domestic violence, you're dealing with people who are very freshly coming out of very dangerous situations. How do I deal with that? How do I make a safety plan? How do I, what is the plan if something happens? You get people calling, this person found me. How do I hide my kids according to the court order? How do I get my restraining order enforced? These are all things that obviously you just really can't. You offer your legal advice the best you can. You let people know if they need something that is, if their safety is at issue, the police are who to call and not me. Or a hospital is who to call and not me. Also, people's definition of what an emergency is really varies in family law. It's an emergency. They're 15 minutes late for the pass off. Okay, not an emergency. They also texted you and let you know. So we're probably going to pull through, but it is an extremely, people are very, very anxious about their entire life and the entire life they've built and very afraid that it's going to be ripped apart from them. And a lot of the times, at least 50% of it is. So it is very stressful and trying to get people, which is why these family law motions in the interim are so important, because really getting people to a place where they can survive the next 2 years of litigation is going to be huge. So a lot of the bulk of this is in the request for temporary orders. So family law courts are permitted to make temporary orders. They're extremely important to draft well. They often frame the entire case, especially as it comes to child custody issues. If in your pleadings you state, I think that Fred should have 50-50 custody of the kids, you're going to have a hard time later saying Fred beats me and the children. Oh, really? Why were you okay with him doing that 50% of the time? If you go in and say, oh, he is an alcoholic and I've never done anything wrong, and then they pull up your DUI record, you're going to have a very hard time explaining that. It is very similar, I think, in concept to the verified pleading, in that everything is under penalty of perjury. They're usually up to 10 pages worth of just a declaration about what your life has been, what you've done over the course of your life, how you're raising your children, what your financial situations are. And the initial request for order is often, the judge's mind's often made up about what they're going to do in the interim before you're even getting into court. So having everything you want the judge to know about your case in these initial requests for order is vital. So temporary orders you can make, support orders, attorney's fees orders, protective orders, and then property, interim property restraints. So as I put in here, as you may have guessed, that you get these orders through more judicial counsel forms. The forms required, you got the FL 300, and then there are tons of attachments. Thank God the attachments are indicated on the initial FL 300. So that FL 300 is going to act kind of like a table of contents to all of the things that you're requesting. In a request that is heard in front of a judge for about 20 minutes max, you may be asking for attorney's fees, spousal support orders, child custody orders, child visitation orders, when you're going to call the child when you don't have them. Can the child be enrolled in softball? Should we bring the child to this doctor or that doctor? Tons of information that you're asking for is in these requests for order. Get everything in writing in these forms, using the forms as much as you can. It takes out a lot of the guesswork about how to word things, a lot of the guesswork about what you are asking for, and lets the judges go through it a lot faster, which is important when you're on that limited time frame. Also, memorandum points and authorities. I think family law lawyers in general get a bad rap, and I think probably 50–60% of them probably deserve it. There are a lot of attorneys out there who put cases and cites on things where it is not what is being represented in that case, not what is being represented in that cite. I have seen people cite things that aren't even cites. You pull it up, it's the middle of some random case, like some random criminal case, and you're just like, well, this is crazy. How could this possibly be in someone's points and authorities? So especially at the beginning, when you are feel so inclined to, I always say, being an attorney is just being a very good forger or a very good plagiarizer, because you were constantly reviewing other people's work and saying, what did I like there? How do I use this? How do I use that in motions? And be careful when you do that, because if you are going to use some examples from other people and incorporate that into your own work, don't take their word for it. I have seen so many that I've gotten, oh, this is a great example of something that would prove X or prove Y. And you go through it and it's just not. So be careful of whose work you may be learning from.
So Brittany, when you were talking a little bit about the emotional involvement of the petitioners in particular, but when you're representing the respondent in these and you get a request for order or a petition coming in, and I'm assuming that they frequently include a lot of ad hominem attacks that may be ancillary or unnecessary for resolution of the underlying disputes. How do you work in terms of the response to that when you're representing the respondent in terms of trying to keep the issues contained to what's relevant to the court when you're putting it back in, and how important is it to engage in a response to those items versus just saying, court, we understand these allegations are out there, we deny them, but we're not going to get into it because it's not relevant to what's before the court.
The relevance grounds in family law is pretty broad. You're looking at things like, what is the standard of life you have led in the past 10 years? That includes a lot of things. You say, what is best for the child as far as living situations? That includes a lot of stuff. That includes, like, do you go out and party every Friday? Do you stay home and help with homework more? Do you do this? Do you that? Is there a drug problem? Is there a, overspending problem? So when you're talking about items that encompass entire people's lives, it almost is kind of difficult to get something that is completely irrelevant. So there is definitely more things that are more relevant than others and more red flags than others. For example, if someone says, oh, I should have full custody because my husband plays softball on Tuesday and that proves that he doesn't love the kids. Yeah, you don't need to spend much time on that. You could just say, you know, I've arranged for a sitter for when I go to softball, but we don't need to spend a ton of time on that. So I think it's ends up being less about is something relevant, but just how important that thing is to the court and how reasonable it is. Also, the weird thing about family law is that really depending on if you're the respondent or the petitioner, you're pretty much in the same place. You're typically two people who cannot get along and cannot come to any agreements. Otherwise, you would not be involving lawyers in this. It is more money than anyone has to spend when they go to a family law attorney. And they are doing it at a time when they have the least amount of funds to do it, because they are trying to take the funds that they have earned in life, split them in half between two people, and then saying, oh, let me take on this huge expense. So it is, you aren't getting people who can communicate well with each other or can really not have an emotional response to the things being said. It is, it's a mess in there sometimes. And it really, keeping your clients on task is important, and they really explain to them why you leave things out, why you put things in, why you need to address certain things. And I'll kind of go over that in a bit too. Just briefly, income and expense declarations. You want to make sure that is, it's a form again. Make sure you're filling it out correctly and accurately. It's asking people a lot of questions. What are you bringing in every month? What are you spending every month? Don't lie. If the court finds you lying, they will not trust you for the rest of your case, essentially. It is an easy thing to disprove, a lot easier than do you love your kid or not, or some other kind of vagary like that. So it's very important that it's accurate. I also threw in here a site that says if you have incomplete, inaccurate, or incomplete or inaccurate or submitted in bad faith income and expense declarations, you can be entitled to sanctions. Ex parte orders is when you need orders faster than the very slow amount of time that the court will usually get you orders. Usually when we ask for temporary orders, we're looking at, maybe 3 or 4 months out to have a matter heard. And if you have a situation where it's who's going to be the school parent and who's going to have little Jimmy on the weekend, 4 months out can be an extremely long time. Sometimes you need those orders faster, but in order for the court to make immediate orders, you're going to need an extreme situation. And also people often say, oh, I can get immediate orders. You're still looking at about a week for the turnaround. So if your child has been kidnapped to another state, for instance, you're still not getting that any sooner than you might otherwise. A few other items to remember: filing fees, serving the other party, using judicial counsel forms to respond. But the main thing, the bulk of all this, is the attachment 10. It's going to be on the FL 300. It's an attachment, and it just says, what are your facts to support your requests? All the forms you're really looking at are just saying what you want and establishing jurisdictional requirements. Everything else is going to be in this attachment, which goes through everything you have to say and what you need the court to know to make the ruling that you need. You could use a separate declaration, but everything needs to be signed under penalty of perjury. Everything should be, make sure if it's a sentence in there, it's correct. And it's a lot of sentences, but going over with your client carefully about exactly what's going on in their life is going to be pretty important for that. For these declarations, like I said, make sure it's accurate. It's amazing how much people put in information that is just inaccurate and easily disproven. And that's not a situation you want to be in, because the response is going to pull anything they can to show that you are a liar and you are the problem and not them. Tell a story with the declaration, which is, such a dumb thing to put in this because it's like what every legal writing thing tells you. But I always tell clients, if you go in there and you say, you know, my husband beat me and threw me up against the wall, but you're not contextualizing it at all, it is a lot harder to believe than when you describe how over time things have escalated, things have happened, things have grown in their intensity. They have arguments have persisted. How 5 years ago things started happening after Blotty's brother died. He started acting in this way. Things that can make the court say, "Oh, I get why that person got here," and all the background of this is making this one incident or this, you know, big fight or the reason why he doesn't show up to Bobby's soccer game more believable. So really going through kind of the life of the client. I always start in these things. How'd you meet your ex? You know, did you go out on a lot of dates? Okay. Like what was your vibe at first? Did you like really get along? I always tell people, tell me what's best about your spouse. The other crazy thing about family law versus civil law is that you're litigating against the person who probably knows you better than anyone else. This person is the person who theoretically, and not always, but theoretically has been someone who is extremely close to you, who you have spent, you know, sometimes upwards of 30 years with. That person knows exactly what your, you know, what your weak spots are, what your bad qualities are, what your things that make you insecure, things that just get under your skin are. And getting, leads me to the next point, getting ahead of the negatives. It apparently is good in civil law too, but it is, I tell people, like I said, if you got a DUI, you know, 8 years ago, let's talk about it in your pleadings first. Because what I don't want is you to go on and say a bunch of things and then have someone else say, oh, but this happened, because if the court thinks that you're hiding things or the court thinks that you're not being forthcoming with information, they're going to punish you for that. So really trying to, in your own declaration, try and get ahead of it. See if you can reframe this. Did you do something that you would consider bad parenting? Great, acknowledge that you did it. Say people make mistakes. I'm working on doing that. I've signed up for a parenting class, and move on. Excuse me. Be clear about your requests. Especially with pro pers, but honestly, oftentimes with attorneys too, you get a lot of people who complain a lot about the other side, don't really get around to what they actually want, just that the other person sucks and they do a lot of things bad and they don't like them and they don't deserve the respect of the court, but don't really come up with the request for the court. Make the judge's life easier. Try and submit proposed orders. Say, this is exactly what I want the court order to say. They love that. Anything that'll make their court day go by faster, their calendar, they'll be into that. Ask for things you know will get granted. Be reasonable. I find that when people say, like I was saying earlier, oh, they missed a soccer game, so I should have 100% custody or things of that nature. Judges, you'll lose credibility not only as the client, but as the attorney, because a big part of family law is preparing your clients. You want to make sure that they're aware of the outcomes, they're aware of the law, they're aware that even though their ex may have ignored their phone calls 10 times, it doesn't mean that the court is going to punish them in a draconian way. It's really important that you're prepping your clients. I'm really hard on my clients. I feel like I get them in there expecting that their whole life's going to be ripped away from them. And then they're, you know, a little pleasantly surprised, like, oh, I thought you said I would never get that. Well, you know, I'd rather under promise, over deliver, but really getting them in a position where they're ready for the harsh reality of things, because it oftentimes is a pretty harsh reality when you're in there.
So Brittany, how do you do that expectation management with the clients when they are so wrapped up in these situations? You know, sometimes it sounds like you've got even potentially explosively dangerous situations and you've got to control the client's expectations going into it.
A lot of it is going over how judges make decisions. I talk to them a lot about how judges will lean towards being overcautious as opposed to undercautious. I often use examples of, if someone comes into court and says, Dad drinks with the child in the car, and then that judge says, whatever, I'll ignore that, and then the child dies in a drunk driving accident, that judge themselves look terrible. That is something that personally the judge has to deal with and in society has to deal with, and will relate back to that judge. They will say, wow, there was a custody dispute and this judge decided X, Y, or Z. It's a huge amount of societal pressure when you're dealing with family law, especially with domestic violence. That's been a huge thing, especially lately, probably forever, but I think especially lately with, I can never say that girl's name right, the one who was murdered after she tried to get a domestic violence restraining order. It was denied. The cops didn't take her seriously. You don't want to be the judge who is saying, oh, I didn't take that seriously. Oh, I didn't think that that person was telling the truth, so I didn't do that. Judges are going to err on the side of, oh, you've brought that up? Great, let's get some alcohol testing for dad. Great, let's sign dad up for a parenting class. That, which is why I always recommend my clients take on that responsibility early on of doing it themselves, because that alleviates the judge from taking a lot of that responsibility. So I do try and talk to them about how judges are making decisions and why they might make the decisions they make. It's an extremely subjective field. I'm talking about custody a lot, which is kind of funny because I actually like the financial aspect more, but it's definitely requires more persuasion in the custody aspects, because it is the first issue, of course, is that standard is almost non-existent. The standard for what should happen as far as custody of the child is whatever is in the best interest of the child. Now, you say, well, what does that mean? Great question. I mean, is it in the best interest of the child to go to Disneyland every day? Probably not. Is it in the best, but does the child want that? Probably. Or, what does that really mean? How do you determine that? How do you make a future determination of what is best for that child's trajectory based on information we have now? So a lot of this is really working through with clients what the court's going to be worried about. The court wants to give custody to both parents. That's going to be their, blank slate opinion, is both parents get 50% custody of the child. Then they're going to look at things that bounce them away from that. So really focusing with your clients about what that judge might be worried about. How do we make that judge's anxieties go away? And dealing with, I think that also helps them deal with results when they say, it does seem like that judge was unwilling to grant this for me because he seemed worried that I would do this, or he seemed worried I would act in that way. Yes, great. How do we move forward then and try for another result at the next hearing? Another thing with these cases that's so insane is that they often can go on for, the child's life. An 18-year case is not uncommon for people to be coming in and out of court. Each pleading you have is going to have an effect on the next one. So really keeping in mind how that will affect it is huge. I have clients who call me from 5-6 years ago. Hey, the kid's going to school now and this isn't working. How do we fix it again? And you're back in court. Some people, I feel like, I've never gotten out of court. So it's an extremely long process with people. And so really getting to them to a place where, one, they trust you. And I think trust comes a lot with letting them know where you may potentially see their weaknesses too. But also, especially in your pleadings, is making sure that they really tell that story, because that story is a story that may be retold over and over again, and making sure that the narrative in that story is the one that you want, because once that's the trajectory, you're going to have a tough time changing that as far as changing things later on.
I think that is actually a perfect point for us to end on, because we are out of time. Brittany, thank you for all of your insights into the family law pleadings and the challenges that go into all of the aspects of it. And Mark, thank you as well for walking us through the civil side of things. I don't see that we have any questions in the Q&A, but we can certainly sit around for a minute or two if folks have questions for the panelists, you're welcome to put them in chat or Q&A. And I'm sure that both of them would be willing to, I'll volunteer them to respond to your emails if you want to reach out to them directly as well. I don't see anything popping up in Q&A or chat. So thank you all for attending. And we hope you've learned a lot. And Anne, I don't know if there's anything you need to do to wrap us up.
No, just thank you guys. That was really very interesting and appreciate your time and thank you all. And you'll get your attendance certificates and some great materials in a day or so. Thank you very much, everyone.
How's it
Have a
still
great rest
light
of the
where
day.
you are, Ann?
Evening.
It's still light where you are.
No, she's still in that lovely
Wait,
conference.
wait,
room.
wait.
That's right. I'm just teasing. Thank you all. Have a
Good
great
point. Good point. We have to start paying attention to that now.
So green out. All right, have a good one.
Good night, everybody.
Night.